As we continue looking at some of the introductory topics concerning the English legal system, I thought it'd be necessary to spend a very brief amount of time thinking about the history of the English legal system, its its historical development all the way through to the modern day. Now, what we're going to do is divide this into two lessons. The first of which is going to explore the history of English law up to the point at which we think about the Bill of Rights, and then we'll spend a whole lesson on the Bill of Rights, just to give us an indication of the major transformation that happens as the result of the Glorious Revolution of 1688 and the monarchical status of James II and then of William of Orange in that particular historical event. Now, this is not going to be in anywhere near the amount of detail that might necessarily be the case for a full course on the history of English law. This is just a very quick lesson taking an overview of how the English legal system developed and the key events that take us from the start to the end. The reason why this is maybe important is because this is a module for the SQE on the English legal system. And so it's important to have a basic idea of where this legal system came from, how this legal system came about. So we're looking at introductory content for the SQE, and we're going to begin with the Anglo-Saxons. The Anglo-Saxons are, of course, pre-1066, 1066 being the Norman conquest. And really, the law, the English legal system as we know it today, develops over the course of basically 1,000 years from this point at which we're talking about the Anglo-Saxons. And then there are major inflection points that take place throughout this period from time to time, in which we see major events that take place and that creates more and more legal developments. So at least when we think about the Anglo-Saxons, the Anglo-Saxon legal system of England and Wales was very, very basic. For a start, there wasn't really an England for the majority of the Anglo-Saxon period. It was something known as a heptarchy, a number of different dominions. There was places like Wessex and Northumbria and other places like that. And they had conflicting kings and they had conflicting ideas. You also have to think about the impact of the Vikings coming in and establishing Danelaw in this area as well. And so for the most part, law as we know it today existed mostly as custom and as customary principles with some kingly codes. Before the Norman conquests, England, the English legal system was mostly customary rather than being derived from any kind of statute. You would have things like local assemblies, namely shires and hundreds, playing roles in the administration of justice. There were also law codes, and development of law codes would continue more and more and more as we go through to the later periods of the Anglo-Saxons. So, for example, the Law of Ethelbert in around AD 600 provides one of the earliest surviving Germanic law codes, recording pre-existing customs rather than issuing any kind of entirely new royal commands. You also have law codes of people like Ethelred and people like Alfred the Great, of course. But a lot of these early law codes were influenced by foreign sources, things like Germanic tribal law, Scandinavian tribal laws, Germanic codes, as well as the Catholic Church. The canon law was also part of the influence here. And you can also read into this some indication of the Romans having influence over this period of history as well, especially given the fact that predating Anglo-Saxons, of course, the Romans existed in England as well. In terms of the societal structure writ large, of course, kingship was central to the Anglo-Saxon system. Many legal concepts were organised around family and kin groups rather than by the state or by any kind of individual in a more modern sense. You would also have the King's Council, sometimes known as the Witan, that served as a legislative institution at the time, a sort of rudimentary legislative institution. Kings consulted their nobles on things like laws, and some codes explicitly recorded this joint lawmaking decision. There was also a distinction during this time period between what becomes known as a folk right, a customary communal law, and a privilege, which is granted by royalty. Over time, royal power and royal privileges would grow and grow and grow, and this would, of course, begin to undermine the purely local customary systems. But it's not until the Norman conquest that we see the first major inflection point in the legal system, because what the Normans did after 1066 and the reigns of specifically Henry II was centralise the legal system specifically. So when William the Conqueror comes and invades in 1066, what he inherits is a quite fragmented legal system. Over time, the royal court, the cura regis, or the king's court, began to assert greater amounts of authority over all the different parts of the realm. But at the same time, there was this recognition that customary laws were still quite important. And so the Normans didn't just come in and create a new legal code and simply impose this law wholesale. English customary practices remained influential, such that the development of a legal system in this way would take place gradually. It would gradually emerge, blending elements of Anglo-Saxon customs with Norman administration. The seminal innovation then for the legal system during the Norman conquest was the use of the writs system. The writs were essentially formal orders that were allowed, that allowed individuals to bring cases into a dispute, bring cases forward. They were formal orders that were originally issued by the King's Chancellor, and over time they would develop into very different causes of actions. So you would have a writ, for example, for land disputes, you'd have a writ for debt, you'd have a writ for inheritance disputes, etc., etc., etc. And royal justices began travelling to localities to hear cases based on these writ systems. These were known as itinerant judges or assizers, and this began to standardise the legal practice and extend the reach of royal justice. So when you have taking these itinerant justices to just go around the country to try and resolve disputes using the king's law, using the king's ideas, then you are starting to normalise and standardise the practice of applying the law equally across the realm, something that, of course, would undermine the customary process of the legal system as it existed prior. As time went on then, the doctrine of precedent began to crystallise. The idea that judges and itinerant justices would look to earlier decisions on similar cases to make case law a primary source of law, and this is how the common law would begin to develop. The High Middle Ages was also an important time period where we see some other major inflections. Of course, by the reign of Edward I from 1272 to 1307, the idea of the statute had become increasingly important. His reign saw many codifications and clarifications of the common law. And some of these early statutes, particularly those before 1285, essentially restated or refined basic principles that the common law had already existed, had already elucidated, rather than creating wholly new principles themselves. And what we start to see then is a distinction begin to grow out of this dichotomy here between the King's Council having what looked to be more and more executive authority, and Parliament begin to develop into its own legislature. And this begins to sharpen as time goes on, with Parliament becoming a primary source of statute law over time. We also see events in the High Middle Ages such as that of Magna Carta, a landmark legal document, not strictly a law code, but Magna Carta came out of the rebellion by the barons of King John, and this, of course, leads to the forcible acceptance of Magna Carta, which established fundamental constitutional principles such as the protection from arbitrary royal justice and basic, quite rudimentary rights to due process, as well as limitations on taxation without consent. During this whole time as well, by the way, running alongside this are the development of principles concerning equity. So, as the common law becomes more and more sophisticated, it also becomes more and more rigid and formalistic. And what we find is that many litigants found themselves in situations where the remedies were inadequate, or that where there are situations in which the common law's strict application meant that there were unjust outcomes, that the law has to be applied in this way, but it doesn't seem to be very suited to the justice that wants to be delivered by this particular case. And so to address this injustice, to address this unbalance, that if you will, people begin to petition the king. And the king would basically look at the cases, and they would apply their own system of law, their own system of fairness, who would then eventually start to delegate such petitions to the Chancellor, who was originally a royal clerk. And what this did was develop over time into a parallel judicial system. As the Chancellor, as the king roamed the realm and the Chancellor came with them, they would dispense equity. They would dispense equitable remedies for quite rigid and formalistic judicial hearings. Over time, and because of practicalities, it became necessary to establish a separate court that would deal with these equitable issues. This becomes known as the Court of Chancery, which administered equity on a basis of fairness or conscience, rather than by way of strict legal rules. The Chancellor would then, often being drawn from the clergy, begin to decide cases on the basis of these equitable principles and begin to develop the maxims of equity to guide decisions. We'll get to equity in a future lesson, and we'll get to equity in a lot more detail when we look at the law of trusts. But as time goes on, as you can imagine, what we're seeing is a parallel structure, which then begins to develop into tensions between the ordinary courts of the common law and the Court of Chancery. A defining moment was the Earl of Oxford's case in 1615, in which it was decided that when common law and equity was to conflict, it would be equity which prevails. And so for centuries, we can see that there is an institutional separation between law and equity, with common law courts awarding damages, whereas equity courts issuing things like specific performance, issuing injunctions, and other kinds of discretionary remedies. And we only get to the sort of fusion of the common law courts and the equitable courts in the 19th century, with the passage of the Judicature Acts. The first Judicature Act being passed in 1873, the second emerging in 1875, which merges the administration of common law and equity together. And so now the same courts could apply both legal rules and equitable remedies. And so there is still a conceptual distinction between these two doctrines, but they are at least procedurally unified in terms of their court operations.